sometimes you volunteer for projects and sometimes you're voluntold to do them. For Brady and PID, I was voluntold to do this back in 2007. And so I've been our point person for this project since then. I'll tell you a little bit about what we do in King County, Washington. Some of this may be very basic, and I apologize if you all have your own programs. That's great. But at least for some of you, this may be new. So let me switch to the next slide. So let me first by saying we started it by calling it our Brady list. And we kept referring to it as our Brady protocol and Brady this and Brady that. And we ended up changing the name. And I'm going to talk to you a little bit about why we changed the name. We're then going to talk about how we started in King County. We'll go through some of the ins and outs of our policy and what's called the WAPA model policy. That's the Washington Association of Prosecuting Attorneys. We'll talk about how PID is handled in PBK, and I realize not everybody has PBK, but I also was doing this PID work in just an Excel spreadsheet for a number of years. So I'm happy to talk about that experience as well. And then some sort of outstanding issues or remaining issues that we're seeing in King County. So let me first start by saying why we changed the name from Brady to PID. Really, it stemmed from the fact that when we kept calling it a Brady officer or Brady list, the courts automatically assumed that this was something that was going to be admissible in court. And they're like, well, it's Brady, so it must be admissible. And we're like, no, it's potential impeachment material. And disclosure doesn't necessarily mean admissibility. And so we had to kind of make that clear. Also, we wanted to be consistent with the state materials that were coming out because all of the offices in Washington State were calling it very different things. And so we wanted some uniformity. I don't think it's wrong to call it Brady, but it may be limiting, and bear with me for a second. But PID really stems from a number of different obligations, at least in Washington State, both from the case law, Brady and its progeny, also in our criminal rules, which talk about our obligations of discovery, and also in our rules of professional conduct. And I have one fancy slide. I know Jason has more fancy slides, but this is my one fancy slide, which is really that this whole concept of Brady is much larger than the case law. It really depends on what your rules of professional conduct and your criminal rules require you to do. And at least in our jurisdiction, a lot of times judges were referring to things that were covered under our criminal rule 4.7 that actually wasn't covered by Brady. Things that were covered, for example, in the rules of professional conduct. So I'll give you an example. In Washington State, we have to provide notice of any criminal convictions of any of our witnesses. But not all of those criminal convictions are, for example, crimes of dishonesty or something that might impact someone's credibility. Somebody could have a DUI, an officer could have a DUI. One might argue that has nothing to do with their credibility necessarily, but it is required under our criminal rules that we provide that information. And so that's why this whole concept of Brady is actually larger than the case law, and for your jurisdiction may extend beyond the borders of the case law. And so that's why we changed the name to PID. So I'll go through how we started with our protocol and where we are now. So back in 2007, a Seattle Times article came out, and it highlighted a number of officers in the Seattle Police Department where there were there was allegations of dishonesty for those officers. And there was a question that was posed by a reporter saying, what are you doing with this information, prosecutor's office? And what I found was that our former chief basically had just kind of a notepad in his desk of officers that had kind of bad stuff about them in the past. And, he would share that. We quickly grew to an office that had at one point, 200 lawyers in it. So that was not a workable system. And our elected prosecutor, Norm Mailing at the time, asked me to come up with a written Brady protocol. This is back in 2007. So I did what all of you would do, and I asked around who has something. And I looked to Pierce County and Snohomish County and all the other counties around me. And lo and behold, I found that nobody in Washington State had a written Brady protocol. So I kept looking, and I actually stumbled upon California, where I found, I think, 5 written Brady protocols back in 2007. Ventura County had, I think, probably the most robust one. Santa Barbara, there's a couple of others. And what I did was step 1 and step 2, which is what I encourage you all to do, is form a committee and borrow some written protocols. And I would suggest that you get several. We formed a committee. We had these 5 protocols, and after 14 or 16 different versions, we wrote our own. And basically, at that point, we decided we needed to start meeting with law enforcement. And so that's what I did. I met with, we have 39 different police agencies in King County. That's a lot. And I met with the 39 different police chiefs, and I met with the police guilds. And, the chiefs and the guilds come at it from different angles, which you may expect. But it was important to talk to them about it. I also explained the law and our obligations. It was funny because many of them asked, is this some new case that came out in 2006? And I was like, no, it's been there since the 60s, right? But we have just been sort of asleep at the switch here. And we talked about what their ongoing obligations were going to be. It's frightening to think that we are on the hook for anything that is in anyone's personnel file for thousands and thousands of officers, and yet we're presumed to know it all. And so I said that it's not going to work for me to go into each of your agencies and start digging through files. It's not going to happen. What we need from law enforcement to provide us is the following things. We need you to send us sustained findings of misconduct involving dishonesty and falsehood. We need you to provide us those criminal convictions, even those that are not crimes of, dishonesty, the DUIs. We need evidence of biased policing and racial profiling. And we need the pending investigations of all of the above. And you might be scratching your head as to that last one. Why do you need to know pending? Well, in 2013, again, we started in 2007. In 2013, the Ninth Circuit came out with a decision that basically said that it's not enough for us to wait for the final determination to be providing this information to defense counsel. We actually have to let them know when there's a pending investigation as well. So we added the pending prong to our protocol that we asked them to provide to us. We also added the bias criteria that was not in our original criteria, but it's pretty clear that impeachment evidence includes any evidence of a witness's bias or prejudice. And it actually, interestingly, it came from a call I got from the King County Sheriff's Office. We had a supervisor call me and says, I looked at something, and, an officer's actions were not dishonest. It was not criminal. But I think you ought to know about this. We intercepted some communication, and he's making all sorts of anti-gay comments throughout all of his communication. And it's not dishonest, and it's not criminal, but I think you want to know about this. And I was like, yep, I absolutely do want to know about this. I went back to that California office in Ventura, California, and I said, do you guys have this? And they said, oh yeah, we have this as well. So we added the bias prong or prejudice prong. Then we started thinking about our experts, who makes a mistake. We had an expert who was getting trajectory analysis completely wrong. They just completely botched the math like a number of times. And we're like, well, if I was a defendant or a defense attorney, I'd certainly want to know that. And so we added an additional prong for our reoccurring state experts, and that is a confirmed performance error that compromises the expert's final conclusion and resulted in corrective action. So if you got your fingerprint tech and they say something's a perfect match, and lo and behold, it's not a match, and they've been disciplined from their own agency for coming up with that conclusion, and they've been put into remedial classes and that sort of thing, that's something that we provide to defense counsel because they need to know that. So what did we ask law enforcement? I told you the list of the topics, but we did not want to be the central clearinghouse for every huge internal investigation, all the paperwork and all of that. We decided we have pretty robust laws here in Washington State for public disclosure that anyone can pretty much get anything as long as you ask for it. And so we said, listen, law enforcement, don't send us the whole IIU file. I don't want that. Brady is a notice issue. My job is to provide notice to defense counsel that there's something there. It's not my job to track down all the paperwork about it. That may be different in your jurisdiction, but in my jurisdiction, this is true. So we said, law enforcement, just give us a blurb of information. I need to know the name and the badge number, the date, the IIU number, a one-line summary, and the resolution. And so, for example, they would send me on March 2nd, 2024, Officer Smith, 3101, was found to have lied in his overtime forms. The finding for IIU 1234 was sustained, and he was docked 2 days' pay. I don't ask for the whole file. I don't want the whole file, but every once in a while, they'll send it to me anyway. If they do, I keep it because I already have it, but ideally, they just send me the blurb. Sometimes, though, PID things happen that happen in court or they happen with a prosecutor present. And in that situation, I have always said that we are not an investigative agency. I'm not doing an investigation. I am referring this back to law enforcement to do their own investigation because they provide due process to their officers and they have a whole system in place. So for example, you see something on a body-worn camera that looks like this is an officer is being dishonest. I will immediately send that back to law enforcement. And I'll say, hey, you guys need to take a look at this for your IIU. Or I've had a situation where an officer came in and they totally lied to us in the court. They said they were on vacation on a certain date, so they couldn't come into court. They had already bought plane tickets. They were never going to be able to make it. And lo and behold, they lied. They flat out lied. I sent that back to law enforcement. I said, you need to do an investigation on this. It's not coming from me. So how do we maintain PID and PBK? Again, not everybody has PBK, but I'm going to show you how we do it in a case management system. But like I said, for many, many years, we got PBK in 2013. From 2007 to 2013, I was maintaining it all in Excel spreadsheets. Not fun, but I was doing it. So in PBK, we flag the person as a Brady witness. When they're first added to the case, a pop-up will appear on the screen of our filing attorney. And it says that this officer that they're adding has potential or has PID. They'll also see it next to the person's name. So here it says potential PID. So it's just an added layer so that they know that there's something there. Then when you click on, you'll see that there's a blue square that says PID information. And when you click on that, it says materials available, and it also has a little blurb on it. It has a sustained finding for dishonesty regarding an allegation that he lied in an internal investigation. It has the IIU number and has the date. This one also says materials are available. So unfortunately, at some point, somebody sent us all the materials. And so now we have to maintain those, and we maintain them in PBK. If it doesn't say materials available, we don't have any materials on it. So what does an attorney do? Well, let's say they've subpoenaed or even not subpoenaed, but he shows up in the police report. What they'll do is they do a disclosure cover letter and they send this to defense counsel. And it explains that we have obligations, that we are providing this under our obligations, and they're going to essentially cut and paste this blurb, and because we have materials, the materials for defense counsel onto this letter. And then that's maintained within PBK so that we can show that we've met our obligation. We also keep track of things that are not PID and not Brady. Thinking, why would you keep track of that? Well, because every once in a while, defense counsel will say, "Oh, I heard about Officer Smith, and I think Officer Smith has such and such." Well, we can check and we can say, actually, our committee looked at Officer Smith, and no, there's nothing there. And so we keep track of those that are deemed not PID as well. We will always err on the side of disclosure, as the Supreme Court warns us not to tack too close to the wind. It's always helpful to get nautical terms thrown in there, but we will always err on the side of disclosure. But if our committee has determined that it's not PID, then it's not PID. I will say serving on the PID committee is not something that people necessarily love to do. I've often said that if I go missing, check the PID list because we make a lot of enemies with law enforcement. Or we get calls like an officer saying, I didn't get hired for this job because of you. And I'll say, no, no, no. You may be on our list, but it's not because of me. I don't make any hiring decisions, firing decisions, promotion, or demotion. We simply have a list that we are obligated to maintain for our constitutional purposes. I'm going a little quickly because I want to make sure we get to the other folks. But let me just talk about some outstanding issues that we see in King County that you may be experiencing. So sometimes we are having courts now make a very specific finding that Officer so-and-so has lied. And that is troubling because it's unclear if they're making just sort of a credibility call. Officer Smith says that something happened on 3rd and Pike, and in fact, it happened on 3rd and Pine. Does that mean Officer Smith is a liar? Not necessarily. They may be mistaken. Or as there may be a hearing where the judge says, I find the defendant's version more credible than the officer's. Does that mean the officer goes on your Brady list? Not necessarily. So what we're having to do and trying to train our attorneys to do is find out, is this a mere credibility call? Or is the court actually finding that the officer was deliberately, intentionally, materially dishonest? We are trying to flesh that out because we've had some very strong rulings from our judges about certain officers. And how to address that can be tricky because as I've said before, typically when law enforcement does the investigation, they have a whole due process for the officer. There's Loudermill, there's all sorts of ways that the officer can add in their 2 cents. When a judge is making this ruling, it has posed a bit of a tricky issue for us, and we've had to go back and clarify with some of the judges exactly what the finding has been. The other issue is just reminding your law enforcement agencies to disclose this. Every year, I'll do my annual sort of shaking of the tree, and inevitably something falls out of the 39 different agencies. And they'll be like, oh, yeah, we forgot to tell you. There was a finding of so-and-so. They've gotten way better now, but when I started in 2007, it was really rough. Now, all the agencies know they have this obligation. We also have made sure that our muni prosecutors have the exact same information that we do, and you should be checking with all the different municipalities to make sure that they match your list. It's not good if they have someone on their list and you don't, and vice versa. We also check with other counties. When you have an officer from another jurisdiction showing up in your case, you should be checking with the other counties and make sure that that person's not on their Brady list or PID list. And then we have some state agencies, Washington State Patrol or the Crime Lab, that needs to send this notice to everybody in the state. There was a recent legislation in Washington State that required each prosecuting attorney to have a written protocol. We used King counties as a basis, and I met with WAPA, the Washington Association of Prosecuting Attorneys, and we wrote a model policy based on King counties. And that has now been spread throughout the state. It's been attached to your materials.
You have 5 minutes left, sorry.
Perfect. So that's been attached to your materials. And so I encourage you to start there and take a look at that and see if that's particularly helpful. Our King County one is now a bit of a relic, and I can probably sunset that and just use the WAPA one. But I do think that it's really important to get everybody on the same page. That legislation happened just about in 2022. So it's pretty recent legislation in Washington State that mandated every office to have a protocol. One question we get a lot, and we're almost at the end of my presentation, is when the Ninth Circuit says we have to provide notice of pending matters, when is a matter considered pending in the time frame? And I get this question a lot from law enforcement. Um, to me, it has to be something more than a mere accusation. So Officer Smith pulls over somebody and says, "You pulled me over because I'm Hispanic, and that's the only reason you pulled me over." And so they start an investigation. Does that mean he's on my pending list? For me, it has to be a little bit more than just an accusation. An investigation has to have started in earnest. Somebody has to look at it and go, "Oh, actually, I think there's something here." And so we talked to the legal advisors, but with 39 different police agencies, I'm pretty sure they're all defining it slightly differently. So it's something to think about if that's an obligation in your jurisdiction into helping them define what pending means and when that matters. One also note just from experience, I've had law enforcement agencies say, "Well, we're terminating Officer Smith, and part of the agreement is when we terminate him, we're going to change the sustained finding of dishonesty to not sustained. And so you should take him off your list." And I said, "No, thank you." I said, "You can do whatever you want to do, but he's staying on our list." And so what we do is we put the little Barry Bonds asterisk next to his name, and we say that this matter was changed from sustained to not sustained as part of a negotiated settlement for his employment, but he remains on our list. And they're like, "Oh, that makes us look bad." And I said, "Yep, it does. I wouldn't do that anymore." So, so you maintain your list no matter what law enforcement does, no matter what they change it to, it is ultimately up to you. Finally, people ask, how do you get off the list? In some jurisdictions, there's like a 5-year, 10-year, or 1-year retire. We don't have that. For me, the matter just becomes less and less probative over the years, but the duty to inform remains. We don't take people off the list just because they retire or because the case is old, because sometimes you have cold cases that you resurrect. And you may need to know in the 1980s, this guy did have a sustained finding of dishonesty, and it is relevant. And it's relevant even if you don't call that officer because they were still interacting with the scene. And so we don't remove people. The only way we remove somebody is if the finding itself is overturned by a legitimate process, like it's gone through the court system, or if new evidence was discovered that suggests that maybe the sustained finding was done in error. But ultimately, that's still our call, and that has created some friction with law enforcement agencies. I want to be mindful of time, so I will say, please reach out with questions. We are still learning as we go. We answer questions for folks all around the country at different times. We brainstorm stuff. My number's there and my email as well. So please feel free to reach out.